Thanks for joining us again. So on the last podcast, we were touching base a little bit on, unlawful searches and seizures. And I think on this podcast, we should take it a step further.
I mean, we did go off a little bit on tangents, different trials, but yes,
that's what happens. So anyways, I wanna talk about Mr. C. Prior to starting this podcast, we agreed who Mr. C was. He was one of our clients who we dismissed a gun case for. And this was very
obviously, for obvious reasons, we can't identify our clients by name, so we abbreviate. But this one is going to be Mr. Z. C, okay.
Mr. C.
Okay.
So this was a very, very interesting case because ultimately they charged the client with the possession of a firearm. And this gun was found in his sneaker back at the precinct on video. So we couldn't take this case to trial.
You can't deny that the gun was in
the sneaker when he bought it at Nike. We couldn't argue that.
Exactly.
No. So what happened was he's driving down Queens Boulevard. He's a passenger in a vehicle. He's sitting in the back driver's seat, and there's 3 other occupants in this car. It's a gold minivan, and this gold minivan is driving down Queens Boulevard, and officers eventually pull this vehicle over with 5 cop cars. One cuts it off from the front, from the side, from all angles. Officers immediately on body camera footage come out with guns pointed at the car. No one knows what's going on. So all the occupants are ordered to come out of the vehicle, and our client is one of them. He comes out of the vehicle, he lays down on the ground, and officers say, "You're under arrest, don't move." What he was under arrest for, we still didn't know at this moment. So the testimony of the officers was that when they ran the plate...
Testimony where at the grand jury or the...
At both, at the grand jury and the suppression hearing that we had, was that we pulled over this vehicle because it had a fake plate, and we actually tried to pull this vehicle over an hour before, and it evaded us. Mind you, this is like a 2005 Honda minivan.
Probably can't drive as fast as a bicycle.
Basically, and officers were testifying that this car evaded them an hour before. So now officers pull this vehicle over, everyone's in handcuffs, and, the driver's responsible for this, fake license plate and no registration and no insurance. And, every passenger who comes into a vehicle is not responsible for the documentation of that car unless he has reason to believe or know that the car is stolen.
But just to be completely fair to the police officers, the automobile exception, right? If they have suspicion, if the police officer has suspicion that there's some criminality and the police officer believes that he's in danger, even the occupants of the car must exit and be secured.
So we had no issue with officers telling them to come out of the car. The issue was how they had them come out of the car. The guns were drawn immediately. They were all put on the ground face first. Handcuffs were put on them.
So at that point, your argument is that they were seized at that point because the law really allows the police officer that minimum detention, like stay outside the car. That's not considered to be a seizure, even though a lot of lawyers try to argue that point at hearings, that when you ask someone to remain, at least when you're asking him questions, that is seizure. The Court of Appeals of New York, even the Supreme Court of the United States has stated that is not a seizure. That temporary question and answer is not a seizure, but your argument is the way they threw him to the floor. At that point, he's seized.
He's seized in handcuffs, and there was testimony from the officer, not only that he was detained, was at this point arrested. And, I took my questions further. I said, so what was he arrested for? Arrested for the fake plate. I said, and he wasn't driving the vehicle. He was a passenger. Correct. Okay. So at this point, officers transport all 4 individuals back to the precinct. Okay, the car wasn't stolen.
But why did they transport your client to the precinct? And to be completely fair to Nick, he did this case all on his own. At the hearing he conducted on his own. In fact, I told him before the hearing, take a plea. He said, no, I'm not taking a plea, and he won that hearing. So, just to be completely fair, it's the way it is. I don't want to take credit for really an amazing job that you and your client did.
So it wasn't so much where I didn't want the defendant to take a plea. I am his advisor. I could only give him all the facts and circumstances. But this was one of those individuals who was not scared. He says, Nick, I have faith in you, and I'm not scared to go to jail if I lose. But I don't believe that they found this gun lawfully. And
so tell us the story. I don't mean to jump over, right? So at the time they take him to the precinct, what was the reason for them to take him to the precinct. I think the police officer in the discovery I viewed said that he was not under arrest yet. We just took him to the precinct to find out who he was.
So no, what happened was they said they were arresting him for the fake plate and that they ran his name and they saw that there was a SAP warrant from years ago.
So you want to explain what a SAP warrant is?
A SAP warrant is a summons ticket, a pink ticket that you get, for example, if you urinate outside in the car or having an open container. And that's, remind me during this podcast to tell you how officers use these SAP quote-unquote warrants that don't exist to arrest individuals out of their vehicle, search the vehicle, and then take and then ultimately find other contraband.
So tell us now, since we're on it, are you suggesting that there are no SAP warrants and they just create
No.
this pretext, this excuse of a SAP warrant?
There are individuals who legitimately have SAP warrants who have not answered tickets from 5 years ago and just didn't have any contact with the criminal justice system or officers. And when they do after these 5 years, they're arrested on them as a warrant. They go to court and it's dismissed. It's a SAP warrant that's 5 years old most of the time. So these SAP warrants, officers, let's say they pull over a vehicle, right? And I've had cases like this. They pull over a vehicle and they ask the defendant or the individual for his license and registration because they observed him to go through a stop sign, which is not an arrestable offense. But now this individual gives these officers his license, his registration, his insurance. And officers come back and say, look, our system shows from our cellular work phone that you have a SAP warrant from 2017 that you never answered. And the individual responds, how? I've been pulled over since 2017. It's now 2023 or 2024. Right. They never told me about this. They're like, oh, I'm sorry, our system shows that there's a SAP warrant. We're going to have to take you in and bring this vehicle back to the precinct.
For an inventory search, right?
So then
quote-unquote inventory search.
Inventory search, because they now arrest the person while driving his vehicle, and the law allows the officer to take this vehicle back and conduct an quote-unquote inventory search.
Well, yeah, but there are certain angles that the law does not allow. For example, if the vehicle is lawfully parked on the street, right? That's
yes.
questionable. Can they take it? They could if they have probable cause to believe that there's contraband in the car, but that's not the case in this case.
Yeah, that's not the case here. So ultimately what they do is they bring this individual back to the precinct, and while they're, quote-unquote, checking to see if the SAP warrant is still active, they already have officers searching the car pursuant to that inventory search. They come back and tell the individual, oh, we were wrong about the SAP warrant. It was a glitch in our system.
But what happens if they do find contraband in the car and there is no SAP warrant? How do they justify that in court?
So that's where I'm getting at. They can't justify that in court, and it just takes the right experienced lawyer to be able to break down that legal issue, because we live in a very technological world now. You can't take an officer's testimony, even if it's credible, that we arrested this guy for a warrant that we thought he had, but we came back to the precinct and we did an inventory search before we even figured out if the SAP warrant was legit.
Are you suggesting that some of the officers really don't care if the contraband, if found in the car, is ultimately suppressed, as long as they get it off the street, right? Under the pretext that they may have been a SAP warrant. But take it a step further, right? A lot of the officers may argue, well, we thought there was, so maybe the judge will give us what's called a good faith mistake exception. We were mistaken, but the mistake was done in good faith.
So I actually see that very prevalent with officers for many reasons when it comes to arresting an individual, even if they know they're violating his constitutional rights. Why? For multiple reasons. One, let's get it off the streets, like you said. And two, maybe this guy's not going to hire a good lawyer. Maybe this guy's lawyer is going to miss this issue and he'll end up in jail.
Yeah, in other words, what if this guy becomes part of the conveyor belt, right?
Exactly.
I get it.
So now with the SAP warrant, this is exactly what happened to Mr. C. Mr. C, while he's already pulled out of the vehicle, handcuffed, he gives the driver's license. He gives his driver's license to the officers. Well, he doesn't give it to them. Officers say, "Where's your license?" He says, "It's in my back pocket." They pull it out, and they search his name right at the scene, and they say, "Oh, you have a SAP warrant. You're coming with us." He's like, "Look, I don't have a SAP warrant. I've been arrested multiple times already. there's no way I have a SAP warrant. They're like, no, you have a SAP warrant. You're coming back to the precinct. We'll confirm it when we get to the precinct.
In other words, they take him to the precinct for investigation purposes,
Yes.
right? Not to arrest. And I think that's what the police officer testified.
Yes.
That was just to investigate. He was
Exactly.
never officially under arrest. But you see how clever that terminology, how they and you see how they do it. So they're definitely trained
But you know what?
to try to beat us.
We had an amazing judge.
Every judge is amazing in that building.
I agree, 100%. But I have tremendous respect for this specific judge. I'm not going to give any names, but
course not.
She's brilliant. And she was able to catch on to what exactly where I was going. Why? Because even though the officer testified,
Well, maybe you made it easy for her because remember, you are the one who put it together, and
course.
it's okay, and it's all right. Like I said, in this profession, you don't need to be humble. So let
me move forward.
Yes.
So ultimately, the officer did testify that he wasn't under arrest. We were bringing him back to the precinct for investigatory reasons. However, the facts were completely different. He was handcuffed. When he was brought to the precinct, he was brought to the main desk where they put a body camera footage in front of him, started taking money out of his pocket, counting it, his driver's license.
Right, but doesn't mean that he's under arrest. As a police officer, that's what this was done for our safety while we're investigating. He can't walk upstairs into the squad.
We didn't need him to. We needed them to at least handcuff him to the bench in the precinct, but they didn't do that. They treated him as every other person who's being placed under arrest. They take him to the front desk. They ask him for his pedigree information, which is his name, date of birth, where he lives. They take out the money out of his pocket. They count it in front of him. And then they took him to the pens, the cells, in the back of the precinct.
He's still wearing his sneakers.
He's still wearing his sneakers.
Okay, interesting.
And now, procedurally, when you are brought back to the cells of the precinct, you're now just waiting for transport to be brought to bookings.
Was he fingerprinted at this point?
Not as of yet.
Okay.
Not as of yet. But they brought him back to the back cells while they're quote unquote investigating to see if he had a SAP warrant. Okay? They take him now and they tell him to strip. And this is all on video. And he says, What am I stripping for? I'm not under arrest. They're like, no, you gotta strip now. So even though they're telling him you're not under arrest, they're treating him.
Right. They're saying one thing and doing completely the opposite. Right.
And I asked the officer, I said, is there a bench in the front of this precinct? He says, yes. And I said, you couldn't handcuff him to the bench? He says, we could have, but we didn't. I said, okay. And ultimately, while they're undressing him, he takes off his shirt, he takes off his pants, and, well, not his pants yet. And they tell him, take off your sneakers before you take off your pants.
I think at this point the police officer turned around and then the video shows that.
Yes. So he takes off his right sneaker, and instead of leaving it right where it is, he flings it across the hallway. So it flies and hits a wall. When it hits a wall, the firearm is still in the shoe. So he goes into the cell now without his sneaker. Officers walking past the sneaker, and it's all on video camera, so that we could have never argued at trial that they lost sight of the shoe, someone put the gun in the shoe. It was obvious it came from his foot.
Right, because the video clearly shows how your client is making the kick, and at that point the sneaker leaves his foot, and you can see in the camera how it lands across the room.
Yes.
And it's precisely where the sneaker was found with the gun in the sneaker.
And I'll give credit to this officer. When she picked up the sneaker, she was in line with a camera.
Right.
So she picks up the sneaker and she looks inside. She sees a gun. She does not move from that camera. If she turned her back, we would no longer see that sneaker. In front of the camera, she puts her hand in the sneaker and pulls out the gun for the camera.
Right. She wanted to make sure that it's on record that nobody planted that sneaker, because obviously that's a possible argument that an unsophisticated defendant would make during the course of a trial, right? Obviously, you see these arguments all the time. Oh, the police officers planted the evidence. I'm framed by the police officers, or I'm framed by the FBI. That is the worst argument that a defense counsel or his client can make during the course of the trial, because the prosecutors, during their summation, because they always go last, right? They have the last say.
Yeah, they go first and they go last.
That's in federal court. They
hit
go
me first and hit me last.
Correct. So they would argue, if we wanted to frame this guy, right, wouldn't we do a better job? Wouldn't we put, we're the government. We have control of all the evidence before that it goes to the defense. We would have done so much more right, to implicate him in a crime.
Yeah.
And at that point, the defense counsel and his client, who make the argument of being framed, basically look like idiots.
No, you never want to go with that argument unless it in fact did happen. I have not yet dealt with a case where that happened, so
I've never. I mean, that's a reach.
that's a reach.
Okay,
There would be no reason for an officer to pick this guy and say, I'm going to frame this guy. I need to waste my time on this guy.
Right, and jeopardize my whole career and the whole
And go to
integrity
jail.
Exactly. That's an absurd argument. So go ahead. I'm sorry.
So, and just to touch base before I go further with the facts and circumstances of this case, in our first podcast, we talked about certain individuals who are not worried to go the distance. And this specific defendant, Mr. C, he was incarcerated during the pendency of this case because he was on a federal hold
Right. He had
from federal court because he violated his...
conditions of supervised release.
Exactly.
Right. So that in federal court, he's also was considered to be charged as a felon in possession of a firearm.
Exactly. So now he was ultimately incarcerated for almost a year. Right before hearings, the prosecutor came to us and said, look, I'll offer him 2, even though he has a bad record.
He was a predicate violent felon.
Yes. And somehow we were getting... So somehow we were getting around the minimums with a certain plea.
Correct.
And the prosecutor was offering him 2. He says, look, all he has to do is 8 more months. And I explained this to the defendant. I said, look, it's 8 more months. If you lose, we're going to trial. He says, Nick. And to backtrack, I told him, I said, we could only appeal this after trial. You would have to lose and be sentenced. He says, Nick, I'm going all the way.
And the judges in the county would they would not give him the minimum after trial.
Well,
that's for sure. Especially he's a predicate.
He had a Hobbs Robbery Act conviction in federal court.
Right.
So, anyways, moving forward, we were able to suppress this firearm because the judge, after obviously I gave them my closing argument,
The cross-examination.
Cross-examination.
What did you argue? How did you put it together?
So I argued that, 1, he's a passenger in a vehicle. They had no reason to arrest him for the fake license plate that the driver had.
Was there a SAP warrant to begin? Was there, or was
So
it,
I'll get to that point because there was no SAP warrant. But I said before they even figured out that he had a SAP warrant, they had no right to run his name. I said there was no reason to. He was a passenger in a vehicle. He didn't commit any crime. The fact, I explained that the prosecutor's position is that anyone entering a vehicle needs to ask the driver, let me see your license, let me see your registration, let me make sure it matches the VIN, let me make sure it matches the license plate, and no one has to do that. That's not their obligation. So I said at that point...
And there was no contraband found in the car.
No.
So obviously if there's contraband found in the car, all the occupants
Yes.
of the car, whether you're a passenger or the driver, are presumed, right, to have knowledge of that and control of that contraband. It's a permissive presumption, not a conclusory presumption.
Exactly.
In other words, it's enough for arrest, right, because the law enforcement is permitted to presume that you had knowledge, possession, and control.
Constructive possession.
Correct, yes.
And that's actually, that puts certain individuals in very, very difficult situations, this whole...
Passengers particularly.
Exactly, like constructive possession. And, the prosecutor's response is usually like, if it's a firearm, let's say, oh, if it wasn't his, we'll get his DNA, and if he's just a passenger, his DNA doesn't come up on the gun, great, the case is dismissed. But the prosecutor very well knows that DNA and the transference of DNA is so simple between 2 friends. So, for example, one friend is walking around with his gun all day in his pocket, and he has a tendency to keep touching it. But during the day, he's touching his best friend. They're shaking hands. They're, at a restaurant together, playing video games in the house together, touching the same consoles. And after he's touching his friend, he's touching his gun. His friend's DNA could end up on that gun.
So you're talking about transferred DNA,
That's exactly.
touch DNA. That we should do a complete podcast on DNA.
We will.
Yeah, that would be an interesting topic all in and of itself.
And the difference between what a fingerprint is and what DNA is and how it's transferred from saliva, from hand-to-hand transactions.
Right, but I just want to finish this case with C.
Mr. C.
Right.
So now, I explained to the judge, I said, so now that we've passed the hurdle that he didn't have to check the license plate, okay, and he had no reason to believe
Driver's
that...
license, you mean?
No, the driver's license plate, that it was fake, that Mr. C, as a passenger, had no obligation to...
Oh, he had no obligation.
No
right.
obligation to figure out whether or not this plate was legitimate prior to entering the car. Now officers arrest him once he's already detained. Not just mere inquiry. They already put him in handcuffs. He's on the ground face first. They then take his license. Then they find out he's a SAP warrant. So I argue that they found out he had a SAP warrant unlawfully in the first place because he was already unlawfully arrested.
Right. So since he was unlawfully seized, right? Anything that afterward becomes fruits of a poisonous tree.
It would have been exactly, and it would have been more difficult if the officer would have testified and said, "Look, we only detained him with handcuffs prior to getting his driver's license just for officer safety." But she didn't testify to that. She said, "No, he was detained. We put him in handcuffs." She was very confident about it, and she didn't know where I was going. So then they find out he has a SAP warrant, and I said, "Okay, do you have a cellular phone? Where you could search to see like if it's still active?" She says, "Yes." I said, "Did you?" She says, "No." I said, "I took him back to the precinct to do it." I said, "Okay, and when you get back, how long was the drive from the location where he was arrested to the precinct?" She says, "About 15 minutes." I said, "In those 15 minutes, did you search?" "No."
So he was arrested.
He was arrested.
Your argument, he was under arrest.
For what? I don't know. Well, I knew what they were trying to say, but lawfully there was no reason to arrest him.
Yeah, so what happened in the end?
So we had our oral summations in court. I made my oral argument. The prosecution made his oral argument. And at the end of it, the prosecutor asked if he could file what's called a written memorandum of law in support of why this gun should not be suppressed. And I asked the judge, I said, "Judge, do you mind if..."
Obviously, he went to his appellate division.
Yes.
Not appellate division, the court. I'm saying they have, each prosecutor's office have their own, divisions. That one of their divisions, one of their more sophisticated divisions, is the division that deals with appeals.
Yes, that's specifically what they do. They're not so much in court. They're more behind the scenes. They're researching case law and putting the motions together. So we come back a few weeks later. The defendant is brought back from jail, and the judge suppressed the firearm. And the defendant was extremely grateful and happy. And the judge told him, the defendant, "Look, I'm not condoning your actions. You were carrying a loaded firearm and you're a felon, but the gun is suppressed." Like, she basically told the defendant, "Don't celebrate about this." But
well, how can he not celebrate
of
about
course,
this?
Of course. And ultimately, the prosecutor had a little bit of an adjournment of the case to see if he was going to appeal it.
Did they appeal it?
They didn't. I think they brought it back to their appellate division unit.
Right.
And they decided not to.
Okay. Thank you so much. The next. Well, hold on. Should we?
I have more.
Okay.
They'll cut that out.
They'll cut that out. Okay.
So
but how do we, I just want to make the transition into a similar case that you were working on.
So I have a similar case that I just suppressed. I just got the decision back from the judge. This is a more complex case. Now, I'm going to call him Mr. W. Okay? Mr. W is driving his vehicle down Jamaica Avenue. It's a bright sunny day, and he's speeding through red lights. He goes through 3 red lights. Officers pull him over immediately. After those 3 red lights, he stops. They come up to the window, 2 officers from each side, and now 1 behind the vehicle. They blocked in his car and said, "Mr. W, you just went through 3 red lights. Is there a specific reason you're in a hurry?"
Is he alone in the car?
He's alone in the car, no tints, nothing. He has a valid driver's license. He's like, "Look, give me your license and registration." He says, "Sure, no problem." Now, the officer did testify that as they were approaching the vehicle, they saw the defendant reaching for something under his seat.
Well, that's such standard language. He looked nervous. He was reaching under the seat. He was putting something in his waistband. That's just standard language. And anytime they say that on a witness stand, whether it's true or not, nobody knows except the officer himself.
Well, that's exactly what they tried to argue because that's where the firearm was found. So that was his testimony from the beginning of this case. That, look, he was moving around when I came to the vehicle, and it looked like his hand was under his seat.
Oh, so you're suggesting that it's completely possible that the police officer retroactively justifies the search by saying, "I saw him do something or move something towards the area where the gun was found."
Exactly.
If the gun would have been found underneath the passenger side, he would say, "I saw him lean over and put something on, reach out to the passenger side."
And there's no way to contradict that because there's no camera.
And the judge will say, "I found the police officer's testimony credible," and that's the end of that.
Exactly. So now Mr. W gives his license, his registration, and insurance, and now the officer testifies to two key points. One, I smelled alcohol on Mr. W's breath. Two, I saw an open container of Hennessy in the back seat. And I'm sorry, number three, that his eyes were bloodshot. I couldn't smell his breath through the video, so I can't confirm or deny that, but I could confirm that there was an open container in the back seat.
You can confirm that because that's what the video,
Yes,
body camera
the body
showed.
camera showed that.
Okay.
The lid was closed, so there was no indication that he was drinking it.
But was the bottle half empty?
It was almost 80% empty.
Okay, so
And-
that's enough for
Exactly.
That's
So-
enough for at least an inquiry. That may be even enough to
It
issue a
gets-
summons and arrest.
It gets very interesting.
Okay,
And his eyes are bloodshot, red.
well, so that's a common law observation in and of itself. Even if he denies giving a breathalyzer test, even if he doesn't want to give a breathalyzer test, as you know, a common law observation by the police officer is enough to arrest based upon the police officer's training. So if he says that the speech was slurred, the eyes were bloodshot, and he acted a little bit like drunk, that's enough for a police officer to detain.
So that's exactly what he testified to.
okay.
He asked Mr. W to come out of the vehicle and stand behind his vehicle.
Behind
His own Mr. W's vehicle. He's now at the back of his vehicle with another officer, and he's placed in handcuffs.
Okay.
So I asked the arresting officer, is Mr. W now detained? He says, yes. Is he now placed under arrest? He says, yes. I said, what did you place him under arrest for? He says, I placed him under arrest for DUI. Okay.
How the hell did you
Look,
refuse? I don't even know where you're going.
I'll
with
tell
this.
you, because he thought he got me. He's like, I got this lawyer. He doesn't know what's gonna happen. So I said, and at this point you started to search the vehicle. Why? He says, well, I don't know if you know this, but the law, he's talking to me
he's
this
schooling
way.
you.
He
He's schooling-
thinks he's schooling me.
Okay.
He says, I don't know if you know this, but because I am arresting him for a DUI and I found an open container in the backseat of the vehicle, the law allows me on the scene to search the remaining places of the vehicle for other open container bottles. I said, okay, that's fine. So what was the next place you searched? He says, well, I searched the driver's side door pocket. I said, so you stuck your hand in the door pocket? He says, yes. I said, weren't you able to see before sticking your hand in the door pocket that there was no alcohol bottle in there? He says, and at this point I paused the body camera footage because when he's looking down, his body camera footage is looking down. He says, yes. So I said, why did you stick your hand in there? You're still looking for alcohol bottles? So he had no choice to double down and say yes. But, at this point, the judge sees what's going on.
What is going on?
That this officer is using the excuse of an open container to now stick his hands in every pocket of this car.
But what should have been done? Let's assume the defendant is arrested for DWI. At that point, are you suggesting that the car could not have been searched at the scene,
At the scene, no.
but rather be taken back to the precinct
Yes.
and conduct either an
Inventory search. That's the only thing they could conduct. If they want to search it for other reasons, they would need to get a search warrant from a judge.
So what's the difference between and obviously I know the answer, but this is for our viewers, but what's the difference between searching a car on the scene and an inventory search? Aren't they the same?
No. So searching an inventory search is after an individual is arrested for committing a crime in his vehicle, any type of crime. If he's driving and officers pull him over and see cocaine on the floor or what they think is white powder, they arrest him, right? Because of that, they bring him back to the precinct because
But they could also arrest him in the vehicle that he's driving,
Yes.
right, on a public
for a
street
suspended license.
for something that he had done before. Let's say there was a warrant out for him, right?
Yes.
So he's not committing a crime in the car, but he has committed crime previously. They can't leave the car on the street.
No.
So they're going to take the car to the precinct and they're going to conduct an inventory
Exactly.
search.
And ultimately, what's the purpose of an inventory search? The purpose of an inventory search is to protect both the officers and the individual being arrested. Why? Because people have personal belongings in their vehicle, and officers don't want to be accused of stealing anything from it, and the defendants want to make sure nothing was stolen from it. So it's for property purposes to make sure that everything is documented when officers have access to the car and they're emptying it out and putting it in bags. That is the only reason why an inventory search is allowed.
But also inventory searches have certain protocols, right?
Exactly.
There has to be a proper authorization. There has to be proper paperwork. There's a list of punch list of the way an inventory search should be conducted. When a police officer, in your case, for example, goes on a rampage of the car at the scene for a DWI, that's not an inventory search.
No.
That's basically
So let me explain
Right.
how I was able to suppress this firearm. So now the officer's next step after he searches the driver's side door pocket, he sticks his hand under the driver's seat and pulls out a box. It's a brown box that's approximately this big and this thin.
So we'll say about like 6 inches thick and about a foot wide.
I would say a foot wide, but I would say,
6 inches, would that fit under the seat?
I think it was skinnier than that.
Okay.
It was a pretty flat box.
Okay.
So now the officer pulls out that box, immediately opens the box, fully loaded handgun in that box. Now he's under arrest for DUI and the possession of a firearm. I was able to break down. Well, I asked the officer, I said, when you pulled out this box, was there anything written on the box? He says, no. I said, did it say vodka? No. I said, did it say gin and tonic? Did it say tequila? No.
So even under his own theory that he's looking for other open containers, you basically, even if you agreed with it, you basically tell him there was no indication here that this was alcohol.
Exactly.
You were in a complete search for contraband in this car.
Exactly.
Without proper protocol of an inventory search. And nobody does an inventory search at the scene. They're allowed sometimes, as you know, to do some sort of like a search of a vehicle, right? If they're in the areas, particularly in the areas that are in reach
easily reachable
but
that's why
by the driver or the occupants. But in this case, your client was in the back by the trunk area.
Well, no,
he was secure.
Well, that's why they testified in the beginning of this hearing that he was reaching, that he was moving around, and I was able to replay the body camera footage and played frame by frame and show that yes, he was reaching. But he was reaching to pull out his wallet. And when you approached him, he had his wallet in his hand ready to, provide you the license, registration, and insurance.
So you gave an alternative explanation.
I gave the explanation, and they couldn't deny it at that point because they tried to, to structure this, that he was reaching under the seat to put the gun in. That's where they found it. That's how they started out this case.
So, and I'm sure you also argue that the search of the vehicle is now, at this point, once the defendant is secured, is not conducted by the police officer for his own safety because he's completely safe because the perpetrator is away from the vehicle and secured by another police officer. So this is a warrantless search.
Exactly. It's a 100% warrantless search. The officer testified that he did not have a warrant. He testified that at this point he was not conducting an inventory search. He testified that inventory searches need to be conducted at the precinct with body camera footage on, with a list, with special clear bags where they could put the stuff in and memorialize
vouch
everything.
it. It has to be vouched.
Exactly.
Correct. You can't just rampage through the cars at this particular point. But please tell me you suppressed the gun.
The gun was suppressed.
And he walked out?
He walked out. He was out on bail during the pendency of this case, and the gun was suppressed. And prior to the commencement of this hearing, prosecutor again wasn't budging. He was charged with a C violent felony, which is a 3.5 to 15-year statute. They were willing to go down to a D felony and 2 years incarceration and 2 years post-release supervision.
I mean, we could talk forever about all the suppression hearings that we've had. Obviously, you can't win them all, right? No. But it's a fascinating area of the law for our listeners to understand that when someone is arrested, there are two different parts of every case. Mm-hmm. One is a factual defense, yes, and one is a legal defense, right? The factual, the legal defense, let's start with that. Before you even argue that whether I knew the gun was there, whether it's my gun, whether my DNA is on the gun, you go through what's called a legal defense. Was the search legal, exactly, right? And once you prevail on that, you don't need to address the factual issue of the case.
Well, remember that case we had in Suffolk County, Riverhead specifically, where they found over 1.5 kilos of cocaine pursuant to a search warrant.
But this was at his residence.
This was at his residence.
Right.
And we were able to controvert that search warrant on motion. And they ultimately had this defendant dead to rights on the facts of this case because he lived in this apartment with his wife, with his daughter. It wasn't a particularly huge apartment.
Go ahead, I'm sorry.
And they found his ID. They found all of his personal belongings, his car keys to the cars that was parked outside. They had video surveillance of him walking in and out of this apartment for over a month. And they thought they had him.
Right. So I just for our listeners to understand, to controvert a search warrant is one of the most difficult things that can be accomplished in our field, because a search warrant is signed by a judge who had already at that point, when signing a search warrant, right, examines the affidavit by the officers that's basically supported by the DA's office. And to go back to another judge and argue that his colleague, another judge, made a mistake or relied on information that was either recklessly submitted by the police officer in support of that search warrant or was an outright lie is one of the most difficult things to accomplish in our field.
Exactly. And ultimately, judges, prosecutors, lawyers, we're all humans. We make mistakes or we overlook facts, or sometimes we're presented with facts that are inaccurate. And this specific case was as such.
The search warrant, I'm sorry. We should really devote a whole podcast to search warrants, right?
So let me just give you the facts of this case, right? The facts of this case is that you have husband and wife who are being surveillanced as known drug dealers, right? They're selling 1 to 2 grams at a time of crack cocaine to their customers. One of these customers ends up getting picked up by narcotics unit. This narcotics unit flips and says, look, if you don't give us who's supplying
That's
you...
another fascinating field is cooperators, cooperating witnesses, informants. The vernacular is you call them the rat.
Aguilar-Spinelli test.
So that's another show that we should devote particularly just on cooperators and the dangers associated with putting a cooperator on a witness stand. Dangers for the administration of justice, right? Because so many of them are so incentivized to lie that their lives depend on it. I'm sorry I digressed. I just want to let our viewers know that to expect a show just based on, arrests based on rats.
Okay, yes. So we'll get there. So anyways, he's now, the husband and wife on separate occasions are both serving this informant. He's wearing a wire. He has a friend in the car who's actually an undercover detective, but he's serving him approximately 15 minutes away from his apartment, right? And because the detectives were not able to establish through their testimony while obtaining the search warrant that whether or not the defendant and his wife were driving directly from the home to the sale and from the sale back home, meaning they could have picked up these drugs from anywhere and sold it to him, not from his home, we were able to controvert that search warrant.
But how were you able to do that? I mean, in all reality, that was your case. It was a Riverhead case. Mm-hmm. You drafted the motion. I don't think I've ever appeared for that case, even though you and I are, partners.
We're a team. We spoke about it.
Correct. And so that was totally your baby. Mm-hmm. And how were you able to have one judge really, overrule another judge's issuance of a search warrant? And you're not talking about judges that are above each other. They are of concurrent jurisdiction judges.
So I was able to take the DD-5s and the reports from all the detectives, and I was able to show that, look, yes, we're not going to deny the fact that this defendant and his wife sold drugs to this person. We're not going to deny that
because you can't. It's there. And we spoke about how you should try a case, right? Certain things you should not deny because you cannot deny them. Exactly. And if you deny them, you lose credibility on every other issue that you could deny.
Exactly. So
stay mute on.
Yeah. So ultimately, I was able to show that even though these sales were occurring, right? Even though he was selling it to this undercover agent, right, with the cooperator. The cooperator and the undercover agent didn't know where he was coming from. If he was coming from the house, right? What if there was a different location where he was selling drugs from and he went to meet up with the cooperator and then didn't drive directly home? So my argument ultimately is if an officer arrest someone on the corner of a bodega who's selling drugs. That's his known spot where he sells drugs every day for the last 6 months, and there's surveillance footage of it. But there's no footage that he goes directly home from this corner bodega and doesn't go anywhere else and comes directly back to the bodega. How are they going to get a search warrant for the home? That means anytime you're arrested for any crime, a gun, drugs in your car, a fist fight, officers.
So you basically argue that before you can enter a man's dwelling, right, you need to have some evidence to show that he harbors in that dwelling contraband. And just because, let's assume everything they say is true, he was selling drugs, what evidence do you have that those drugs were stored in the house, or any proceeds of those drugs were stored at the house?
Exactly.
And you argue,
and we'll get deeper into it on a different podcast. Well, we could devote a whole podcast to the motion I wrote, because it took me, I would say, a good month to go through all the discovery just to write this specific motion.
I mean, you got involved in that case, I remember.
You were right when motions were due.
Right. You were not the original attorney on the case, and I think the prior counsel was pushing him to take a plea.
For 10 or 8 years.
I think, yeah, it was, well, whatever it was, 8 or 10, it's still a significant number. Yes. And you got involved in the case, submitted, filed these motions, had a hearing on it, and were able to suppress the contraband and got him a...
He came home the next day. He had time served because he was on over $1 million bail they set on him. So he was sitting in jail for over almost a year during the pendency of this case. The prior attorney was waiving speedy trial time to work out a disposition, and the family hired new counsel, which was us, once the lawyer was pushing the 10 or 8 years down his throat.
The speedy trial issue we talked about in our prior podcast is an interesting issue that we should really devote a whole session to.
Yes.
It's a lot of people obviously come to us and say, well, the case is old, how much time do I have, and back and forth. It's a fascinating issue, and we should talk about it.
Well, I was just retained on a case. It's a year and a half old. They're charging him with a gun. I come to court. I look at the date of arrest. It's a year and a half ago. I come to the client. I said, look, I think your case is just going to be dismissed pursuant to CPL 3030, which is the speedy trial clock. It ran out. I pull the file from the court. His prior counsel has been waiving time.
Or maybe he had a good reason. We have to find out.
Yes,
we have to find out.
The offer is still the same from a year and a half ago. That's what's interesting. So to waive for a year, waive a defendant's speedy trial time for a year and a half to have the same offer, it seemed to me that specific attorney was just worried to go to hearings and trial. But he has a good case. He has a very triable
Sometimes
case.
it really to the benefit of the defendant to get up to keep waiving so you can negotiate, right?
Sometimes, yes. And that's what we'll talk about in our podcast.
Correct.
We'll see when is an appropriate time to waive, or when is an appropriate time to just say, you know what, this is what I'm faced with. It's not, the offers are not going to get any better. I'm going to either fight it or I'm going to take a plea. I'm not wasting time anymore.
So we'll do that next
Yes.
next time.
Thank you for joining, guys.